First things first, Trip Watson with the Watson Firm. We're going to talk a little bit today about the legal side of branding. Branding is a hot topic word right now, and as y'all can refer to the handouts that I've given y'all, branding's obviously been a hot topic word over the last couple of decades, and especially now because you get a lot of brand specialists that may or may not be brand specialists about, as I'm sure you know, that pop up and say that they know how to do a lot of this stuff, but it's on top of just being marketing and recognizing what your business is and how to protect it or how to portray it to people, but it's also about protecting legally your business's brand as well. So what is a brand? A brand is a nebulous definition that we give to an assortment of trademarks. Trademarks are legal concepts. So generally, a brand is an intangible asset that actually occupies a line item on most businesses' balance sheet. You can put a number on it. Sometimes that number is negative, but a lot of times it is the largest number on the balance sheet. It is a calculable, intangible asset that brings a lot of value to a business. So I'll walk you through a brief history of trademarks and how we got here. Very first thing is the very first trademarks were Roman metal workers like to stamp in their signatures onto whatever they were making, whether it be swords, pots, or anything else like that, so that they could say, this is mine. You can identify that it's a quality product, and some hack over in Sparta didn't make this, I did. So that was originally the concept. It was to identify your products to somebody else. We fast forward through time, we get to 1383, where we have the longest operating trademark in history, which is Lowenbrau, the beer. They have a lion that is a registered trademark now, but they have used that trademark since 1383. It's the oldest continually used trademark in history. We started seeing some of the countries start to codify trademark law in about the mid-1800s. Specifically, England in 1875 put in their first trademark law, and the very first registration was Bass Brewery with the red triangle. So clearly, the leading innovators in the trademark industry was all breweries and those guys. So Bass Brewery was the very first one. They had a red triangle that they used to identify their business, and that's been the longest continually run trademark in the English-speaking world. So, Hattie, go ahead and grab your seat anywhere you want.
Hey.
Just a few years after that, we had a convention called the Madrid Protocol. It was set up, and it was an international body of folks that came together that said that they were going to create trademarks in multiple countries through statute. So we're talking a little bit about what the brand is, and a brand is simply a collection of trademarks. So we're talking a little bit about the history of trademarks. While the 1891 Madrid Protocol provided kind of the international structure of trademarks, it's not had a whole lot of power until like the last decade. Because that's when the United States became a member of it. So for the better part of the 1900s, the United States was not too big, or better part of the 1800s, the United States was not very big on intellectual property, specifically trademarks and copyrights. It's funny, this is a little bit of an aside, a lot of our problems that we have with China, with their copyright and trademark infringement, they're doing a lot now what the United States did in the late 1700s and early 1800s. We were known as the world's copyright and trademark infringers. So past is prelude. Now we're complaining about China taking our brands when we were doing the same thing for British products because we weren't very big fans of them. But anyway, that changed in 1946 when the United States passed the Lanham Act. The Lanham Act was the very first enforceable trademark statute in the United States at the federal level. There had been a couple of iterations before. Courts had struck it down and narrowed them down, and finally the Lanham Act was the one that sticks. We'll talk a little bit about that later. And then in 2003, just 10 years ago, the United States finally opted into the Madrid Protocol, which allows for international registration of local trademarks and international registry of trademarks. So, anyway, moving on, what is a trademark? We've talked a little bit about what a brand is. Now let's talk about the bundle of trademarks that ultimately come up through this. A trademark is anything that a business uses to identify itself or its products in commerce. Now, that's a broad category because it is a broad set of protections. Now, when you're talking about trademark, it is one of 4 types of intellectual property. Copyrights, trademarks, patents, and trade secrets are the 4 types of intellectual property. And I've spoken before about some of those, but copyrights, they protect specific expressions of an idea. Patents protect against a product or a process for creating a product. Trade secrets are anything that you have of value inside of your own business that you don't make public. Howdy, Lisa. Grab your seat. And finally, trademarks are anything that a business uses to identify itself in commerce. Specifically, that typically means that trademarks are logos, their businesses' names, their slogans. They can even get more specific, such as the way that you package your items, the color schemes that you use in marketing. It can even get more obscure, such as sounds, such as jingles. Call Goldberg. Yeah, that's a trademark. Another interesting trademark is...
Smells.
Yes, Abercrombie and Fitch famously trademarked a smell, that cologne that they pump out and they infuse into all their clothes. They've trademarked that. They're currently suing Beyonce because she has a similar smelling and similar sounding perfume. So there's some interesting ones out there, but you can tell the power of a trademark when I mention the industry and their mark. If I talked about a fast food restaurant that's colors were yellow and red, what would you think of? What about lawnmowers that are green and yellow?
John Deere.
That's the power of a very strong trademark, is there's instant identification of the trademark and you can identify it. Additionally, that company can carve out its own niche with a trademark and say, this is our protected landscape. So if you come in with another company that's going to call themselves Pete's Lawnmower Factory and his colors happen to be green and yellow, John Deere can come in and use the federal court system to make them stop. So, in order to make sure that a trademark is protectable and is strong, it has to be non-descriptive. So you can't open up Frank's Lawnmower Services and say that that's a trademark, because it's lawnmower services. That's simply describing what they do. Now, you might get something that's entirely off the wall and completely unrelated. You might have Frank's Lawn Services, and it might be a bar. That's entirely unique and fanciful is what the term is legally, because even though it's a descriptive term, it doesn't actually describe what they do. It just happens to be something random out there. Another good local example, Ted's Garage. It's a bar. It's not a garage. Even though they have cars in there, that's not the services that they provide. That's a fanciful or a unique mark. So anything like that is a trademark of what you have. However, if you're going to be specific about what you're describing, even personally, if I were to say the Watson Firm Legal Services, that's merely describing what I do. But if I were to give it a fancy name, like using my logo, Atlas, or something that removes it from describing what I do, then it becomes fanciful or non-descriptive, and therefore deserving of some level of protection. Now, on this big scale, you have fanciful, and then you have descriptive marks. Pretty much everything is protectable until you get to the area that's called suggestive marks. And these are inherently weak marks. So you might not be actively describing what it is that you do, but you're suggesting what the result is or what your product is. So, for instance, say you had a lawn care service and they called themselves Short Greens. That's kind of a suggestive trademark because they're talking about producing short greens. So it's a trademark, but it's a weak trademark, and we'll talk about why that's important later. But basically, once you get past the suggestive or the descriptive marks, and especially if they get into fanciful, like if you want a fantastic example of folks that use trademarks very, very well, look at the pharmaceutical industry. They pump out trademarks all the time, and they mean absolutely nothing about what they do. Lipitor, Xanax, none of these have meanings outside of their fanciful marks, but they describe a product. And I'll talk about why that's important in just a second. Trademark law is unique because of all the laws that have been passed down through common law. It's one of the few consumer protection laws. And when I say common law, I mean the legislature didn't draft it and put it into place. It's that the courts have interpreted and said, we're going to give you a right to this, even though there's not a specific law on it. It's one of the few consumer protection common laws. So it doesn't matter necessarily that I have a mark and that you've infringed it. Ultimately, the standard is we're protecting some third party that cannot figure out the difference. So it's a very unique area of law, and again, I'll talk about how that's important later. So, very first things first, how is a trademark created? The simplest way, very much like a copyright, is to start using it. That's the easiest way to start developing a trademark. The right to a trademark attaches immediately when you start using it. However, there is a big caveat here. It only protects you in the industry that you're in and where you market it. So say, for instance, you have Frank's Lawn Service, which is a bar, but they only operate in Birmingham, Alabama. As soon as they start operating Frank's Lawn Service bar, and somebody opens up across the street calling themselves Frank's Lawn Service, then they could sue them for trademark infringement. It would be a common law trademark infringement. However, if Frank's Lawn Service opens up across the country, it's going to be a little bit more difficult to prove whether or not they violated it, because all you've done is marketed in one little area for a short period of time. There's no likelihood for confusion. And that's the standard in trademark law, is likelihood for confusion. Now, if you want to have increased protection without actually having to go through the registration process, you got to pump some money behind your trademarks. So that means advertising, getting the name out there, increasing the geographic area of where you might be providing goods and services, also increasing the range of goods and services that you might operate under. Because keep in mind, a trademark identifies goods or services in an industry and in a geographic area. So say, for instance, that you don't actually have, we used the example previously, fast food. You might not have a trademark in fast food, but you may not have a trademark that extends into fast coffee. So just because you are in one industry, another industry can be shaved off pretty easily unless you take the steps to protect it. If you want to get maximum protection for your trademark, you have to register it. It's not necessary that you register after you've started using the mark. There is a way that you can register before you've ever used it to get protection. And then if you have already started using it, even if you've been using it for 300 years, Lowenbrow is an example. They've got a registered trademark, but it took them 200 years to get a registration scheme for them to get it. Even if you've been using a brand or a trademark for a decade, you can register, and in some instances it can relate back to when you originally started using it. But if you want that maximum level of protection, you've got to register. Now, who owns a trademark? A trademark is just like a car or a house or an accounts receivable account or anything that a business might identify. It can be owned by a person, it can be owned by the business, it can be owned by a group of people. One of the most interesting trademarks that's out there right now is fair trade. It's a trademark, but it's used by a group of people to certify goods and products that are made by other parties. So it's owned by a group and it's a certifying body. That happens a lot. You'll definitely see it in like financial services industries where there are certifications that are trademarked. It can be bought and sold. You can sell your trademark to somebody else. You can give it away. You can will it to somebody when you pass away. You can also license it. This is the foundation of franchise law, is we've got a mark that's readily identifiable, everybody knows what it is. We're going to license you the right to use this mark wherever you may be. So for instance, just down the road we've got an Arby's down here. I guarantee you that Arby's corporate doesn't own that store, but they own the trademark and they license that mark to the individual that actually owns and operates that store. They might charge a licensing fee to use it. It might be a flat fee or it might be a royalty. There's different ways to set that up because just like any other asset, it is sellable and you can set the terms of whatever it is you want to sell. So I want to be able to use your mark. Okay, well, here's a flat rate, here's a royalty, or some other agreement that we might have that goes down the road. So there's
no timetable associated. I mean, you don't have a...
Not by statute. So anytime that you set up with somebody else, trademark protection or whatnot is typically governed by the terms of the contract. So if you give it away, then you can't come back and claw it back. But if you license it, you retain the rights, and they are given the limited right to use it in a certain area. So, anyway, there's lots of ways to skin that cat, basically. Next point is, when is a trademark enforceable? Because that's the other side of it. Give you a lawyer answer on this one. It depends. Like I mentioned before, that little bar that was in downtown Birmingham that had a competitor pop up right across the street, if they'd been there for 2 weeks, might not be able to say that he has a trademark because he hasn't actually established a strength of a trademark. Now, say that same bar has been there for 100 years. He's probably established a strength of trademark, especially if he's been able to survive for 100 years. And if somebody opened up down the street, they'd be able to exercise against that. So it really depends on, in a common law mark, a lot of different factors. When you started using it, in the applicable market. So say, for instance, they opened up another store in Atlanta. Well, they wouldn't be able to claim when they started using the trademark in Birmingham because Atlanta's where we're at issue. However, there's a different way to go about it. You can register it. And it becomes protectable as soon as you register it. And like I mentioned, there are some situations where it can relate back. The reason is because registering a trademark puts everybody else on notice. So they're assumed to know that there is a trademark out there. And that by using that trademark or not using it, you've been notified that somebody else has a right to this mark. The benefit of trademarks and why they're so powerful is because they never go away. So long as you use a trademark, they can last forever. Lowenbrow still uses their trademark lion. They have been doing it for 700 years. They're not going to slow down. A fantastic example of this is Tarzan. Copyright law, which is something that a lot of trademarks get founded on. For instance, you might have a logo that is copyrightable but also a trademark. It can fill both of those categories. But something that is copyrightable could ultimately lose its protection. So back in the early 1900s, copyright protection only extended for 30 years. So the author of Tarzan realized that he could backdoor it and make his rights to Tarzan last forever by trademarking them. So he trademarked the character Tarzan and the other stories that went along with it. So for anybody to use it, they would potentially be involved with trademark infringement instead of copyright infringement, which gives a very powerful protection, but only for a relatively short period of time when you're looking at the potential of lasting for hundreds of years. So